about your business.
Thank you very much.
You're all set, Shane.
Thanks.
Thank you. You bet.
Thank you.
You're welcome. Thank you, Shane. Yep. You're all set.
All right, Mr. Reed.
Mr. Brown is here.
Mr. Brown came rolling in, and I'm inclined to cancel his bond. So I'm gonna give you a few minutes to talk. to him.
Thank you, Your Honor.
And perhaps some agreement can be reached. Mr. Brown, we had a jury trial scheduled for today, and you were at the top of the list. But your lawyer couldn't find you. You didn't call him. We weren't able to figure out where you were. We didn't know whether you were gonna show up or not. And I wasn't gonna bring 30 jurors in here on the off chance that you may show up. What Judge Pattison and Judge Stutson do is cancel bond in such circumstances and make sure you show up for the next case. So I'm gonna give you a few minutes to talk to your lawyer, Mr. Johnson. Maybe we can work something out here. All right. Casey,
Recommend no jail.
I'm glad that was a disturbing piece.
That's okay, Judge. That's fine. No, you can sit in jail and think about it.
What's that?
You can sit in jail and think about it. I'm sorry, Judge, what was that?
That was good to do it disorderly on that case and get that one done.
I agree. It was a good one to get off the deck.
All right, well, we'll wait a little bit while he talks with his client. In the meanwhile, when he gets back, we can talk about Mr. Preston. I believe the complaining witness, Mr. Brooks and Mr. Roman are watching this. I'm not very happy with Mr. Brown, and we will see what we do here. And you filed an order of nollie-pros and Nicole Schultz.
Yes, you should have that.
It's here yet.
It's in my pile, so if you don't have it now, it should be on its way somewhere.
Don't think it's here. That would be, I'll go on the record. File 2131364, People versus Nicole Dawn Schultz. Ms. Schultz is whereabouts unknown. We'll have to make a record with Mr. Reed. I'd like to apply that bond to restitution for the guy that lost his clothes. So we'll wait for Mr. Reed to come back. I do have a $100 bond posted. All right, well, we'll just wait a few minutes. It does look like we're gonna have a trial next Wednesday. And I'm guessing it's gonna be disturbing the peace case. Although it's not the most compelling case, I don't think it's going away.
It may be. We've struggled to resolve that one.
Oops. Oops. I'm thinking Lard, in light of her other stuff, will resolve.
I believe so. I had forwarded an offer on her, so I'm sure Melissa will be talking to her client about that.
Despite TJ's protestations that he didn't get notice about that, he did get notice. But there's also a county case, and then Thompson, Ryan Thompson, Does that look like that could settle, or we'd have to do?
That's a good question. That's still, that's the wild card right now, and I'm hoping to know by the end of the day where we're at on that.
I'll be gone today and tomorrow. And, I'll be back. All right, our next matter is 20662 SM. Are you Christopher Sean Brown?
Yes.
Mr. Brown, you're charged with aggravated assault. The allegation is that on March 10th of 2020, you hit a man and broke his nose and face bones in colon. This is 2 years old. That's extremely embarrassing for me. This matter was set for a jury trial today. It was set once before, and we continued it because Mr. Reed wanted more time to talk to you. This is a very serious case, and the matter's been languishing for 2 years. The matter was set for jury trial today, and talking with your attorney, we thought we were going to try this case, but he indicated he couldn't find you. He didn't respond to his letters, and he didn't have a phone number, and was unable to have any contact with you. And as I indicated, I didn't want to bring in 30 jurors on the off chance you might come rolling in here this morning. Mr. Reed, what's the circumstance?
Thank you, Your Honor. Well, Mr. Brown, even back in 2020, was battling homelessness as well as mental health issues. He continues that. He was residing in Coloma area, Waterville Elite area, I guess. He lost that housing in January. He has been homeless. He's actually been to a mental health facility for part of the time where he stayed, and other homeless shelters. He does indicate today that he has obtained a new cell phone. Prior to that, he never had a cell phone. It was always contact through other individuals. His brother is with him here today, who is attempting to assist Mr. Brown. I do have his contact information. So I guess while it is discouraging, at the same hand, Mr. Brown had no home, no phone, no money, other than what little bit he gets from his disability, where he is his own payee. But it's a situation where I think it's easy for Mr. Brown to fall through the cracks of the mental health system as well as other areas. So he's trying, he's here. I've indicated to him that he needs to contact my office with his new cell phone number. It's out in the truck. He doesn't have it memorized, but he does know it. I give him another business card of mine with my contact information if he can. And I also have his brother's information that I can update my file with the potential contact. So at this time, the prosecutor has offered 1 count of assault and battery. Mr. Brown's indicated he's not interested in that and wishes to set this for trial.
All right, thank you. Mr. Brown, we're going to set this for trial. I'm going to cancel your bond. You're going into custody, and we'll try this case within 28 days.
Your Honor, I guess I do have a question. Is canceling his bond for what violation?
For failing to remain in contact with his attorney pending a trial.
But I don't think he was more frustrated than me that a client won't contact me, but I'm not sure that there is a bond condition in which he's required. I don't believe it's lawful.
You can appeal it. I find he's in contempt of court for failing to stay in contact with his attorney. This is the procedure Judge Stutzman follows, and it's also the procedure Judge Pattison follows. He has a generous plea offer of an assault and battery when he broke someone's face. The matter was set for trial once before and adjourned because he couldn't make up his mind. He's been off the grid for a long time. In this case, is 2 years old. So
I have a stack of mental health papers. I mean, this is an individual, the court is putting a mentally ill individual in jail
for breaking someone's face and
Well,
being
let-
off our grid on a 2-year-old case.
He has not been tried for that matter, and he has maintained his innocence in this. So the court is essentially saying, you have a good plea offer. I'm mad we're not trying the case. I'm going to cancel your bond. Mr. Brown is not somebody who I guess,
You haven't asked for a competency evaluation.
well, it's not that he's not
The
competent.
case is 2 years old. We were here once before. There was discussion. He couldn't decide what he wanted to do, so he asked me to kick this down the road, which we had to do for many months because it's hard to schedule your cases. There's a person that got assaulted here who's angry about this and upset about it, and it's 2 years old. And because of your client's cavalier attitude about the trial in the matter, we haven't been able to do it. So I don't trust him to show up the next time.
You can ask for competency evaluation. I mean, I'm not necessarily sure of my experience that competency and mental illness are two separate issues. I've had many.
Well, that is true.
And again, I don't want to waste state resources on a competency evaluation when I believe that the standard for competency is so low. And it's essentially, if you talk to Mr. Brown, I mean, I've asked him the questions that I generally would ask to determine whether somebody is competent to assist it. And the answer is, I believe he is competent. I'm not a professional, but I've dealt with enough of the cases that I believe that he is. But as far as this other management of life skill and managing life, I mean, the police report indicated they couldn't find him because he was homeless and he had lost his housing and that he was struggling back and forth. And I've got documentation that he does, and he's been in mental health facilities. So, I mean, I understand the court's frustration. As I stated when I first stood up, nobody's more frustrated than the attorney who's trying to represent and has to come before your honor and before the prosecutor with a client who doesn't show up or keep in contact. But I also have to look at my client's interests, as well as there wasn't a bond condition that said you must stay in contact, and the court is frustrated. He is here. He showed up at every court date that we've had. He's never not appeared. And I was prepared, and I don't blame the court, by the way, for canceling the jury. I concurred with the court's decision because it was unclear. But at the same hand, I was prepared to just move forward with a trial. If the court would have said, tough nuts, Mr. Reed, you're trying the case, I would have tried the case today. So I would ask that the court set this for a jury trial within 28 days, but I believe canceling the bond and putting Mr. Brown in custody and in a position where I'm unable to appeal based on not being in town for the next 10 days is a disservice and not justice to my client. And he is presumed innocent. And so while Mr. Broman can be upset, I appreciate that. I don't blame him for being upset. I can empathize with the position. But the idea that he's mad, so we're going to cancel a bond before trial because he's mad, I don't believe justifies the cancellation of bond. Thank you.
Mr. Johnson, what's your thought on this?
Well, Your Honor, I think the issue of bond is to ensure that the defendant shows up. Admittedly, he has shown up on both jury dates. However, we're dealing with the same situation we were dealing with on October 6th of last year, where he would have been told at that time to make contact with his attorney so he could prepare for trial. He has not done so once again. If the court doesn't cancel his bond and lets him walk out of the courthouse today, we're running the risk this happens again. At some point, we need to hold this trial. The victims deserve justice. As the court noted, there's an offer on the table. There's been a lot of work put into this case by all parties except for Mr. Brown. I think the only way to ensure that Mr. Brown is both in attendance and has had an opportunity to participate in his own defense is to revoke his bond and ensure that everyone knows where he's at until there's time for trial. So I agree. I believe the bond should be revoked at this time.
And I would state, he did contact my office since the last court date of October 6th. I have a letter that's marked December 14th from Mr. Brown, which was after the last hearing. It was after that date that he lost, and it had the 3,000, I'm not going to put the address out there, but the address in Coloma that we had, and which was the address I'd been using, and it then got returned, or after that, he lost housing there. But he was in contact. I do have a letter postmarked by the U.S. Post Office, December 14th, received into my office on December 16th.
Mr. Johnson's right. This is the second time this happened. He was here on October 6th and you weren't able to have contact with him prior to that date. So we had to bump it all the way from October to March. This is akin to the statute where a person voluntarily presents themselves on a warrant, which is found at 762.10D. Except in cases where a person has alleged to have committed an assaultive crime, and there's a bench warrant, there was no bench warrant, but there was about to be. If a person presents himself on the warrant within 2 hours of appearance, the court must arraign the person and set his or her case for the next set of the criminal proceedings. Must be presumed that this person is not a flight risk when the court sets bond or other conditions of release. An assaultive crime includes this, an aggravated assault. I'm not trying to bully you into taking a plea, Mr. Brown. You don't have to plead to anything. You have to show up. Your bond's canceled. It's on you. We're going to try this within the next 28 days. This is the second time we've had a jury trial where you've lacked contact with your attorney. The court has every Wednesday available. The question is when we can make your attorney available. He's very busy. And we went all the way from October to March because you weren't ready in October. And then we show up again today. You haven't spoken to your lawyer in months. Like, what's my defense? What witnesses do we need to call? What kind of questions is the prosecutor going to ask? You didn't do one minor thing to prepare for the case except show up twice unprepared for trial, to the detriment of the system, the detriment of the complaining witness in this case. We would know this is an aggravated assault case. So you can go with a court officer. We will schedule this matter as soon as we can fit it into Mr. Reed's calendar, either on my day or Judge Patterson's.
I can set it now, Your Honor. I think, well, actually that just opened up, I believe, end of April, and Wednesday, jury day. I was supposed to have a jury trial on the 19th in circuit court, but that appears to have resolved. I believe that's the 20th is the date I'm looking at, Your Honor.
Those are Mr. Gibson's dates, but unless this matter is resolved,
Okay.
we can put it on April 20th.
If the court would get a notice out as soon as possible, put that on my calendar and I'm available that day.
All right, we got a couple other things to do here.
Well, I mean, obviously, I realize I won't get it out this second, but.
All right. We've got people here. Which case are you folks here on?
Lorenzo Gomez Sanchez, we were with the other lady on the other building. She said, go in and see the judge.
I bet Judge Patterson next door.
It's just a minor traffic.
Yeah, I think it's gonna be next. I think it's Judge Patterson. He got arraignments, Your Honor.
Well, I don't know if it's a pretrial or an arraignment. Let me
It's
see.
just, it's the first time that.
It's not a pretrial, I can tell you that, Judge.
Yes, it's in the court next door.
Oh, sorry.
You're fine.
Sorry about that.
All right, now let's talk about what else we got left here.
Mr. Preston.
Yes, let's.
I'll be right on home. Meet you on home.
Okay,
Thank you.
I got a bunch of this stuff
In your truck?
yeah,
I'll meet you on the hall.
okay.
All
Thank
right,
you.
this is file 202512, people versus Charles Preston. This is domestic assault. The complaining witnesses. This is also a 2020 case. Set for jury trial today. The defendant has failed to appear. What can you tell us about this, Mr. Reed?
Well, my understanding, I don't know this, I did not check. I was advised by, I'm not sure if it was Prosecutor Johnson or Prosecutor Davis, that Mr. Preston has a bench warrant out for
I
him.
believe he does.
So, and again, I'm not sure what the bench warrant was for. However, I've had no contact with my client. The phone number in which I have is, at some point, I had contact in the past, but I've lost contact and the numbers that I have no longer work. Without giving the addresses out, I did send notice of today's hearing to a road in Colon that was updated to my office. That was not returned. So
You are right, there is already a bench warrant out, so there's no matter. I think we said it knowing there was a bench warrant out,
I think
saying
so.
maybe we could find the guy in the meantime.
Correct.
It was your day, and so we
Yeah.
put it in there, and no need for extra bench.
So we had attempted, and again, I'm not even sure what the bench warrant's for, but is it a new warrant or is it just a bench warrant?
It's a bench warrant for failing to appear in this case.
Okay.
All right, that leaves us one matter left, Nicole Schultz.
That was dismissed, is my understanding.
I understand, I haven't signed it yet.
Oh, okay.
There is a $100 bond. There was a restitution request of $390. Mr. Johnson, would you do the dismissal under the condition that the bond be allowed to go for restitution?
Yes, Your Honor. that
No
makes-
objection.
That makes sense.
All right, at least he'll get something for his missing clothes.
That was ultimate. I mean, we were trying to fashion some type of event that way. I mean, this has been $100 might as well be $1 million at some point.
Bond may be released to the complaining witness whose name is Anthony Fuller.
Yeah, there's no objection. Well, no, Anthony Fuller is the officer.
All right, can you tell me who the complainant is?
I was gonna say, I'm sure Fuller would gladly accept a crime fighting bonus, but I don't have that data with me.
I don't.
I think Trooper Lackey used to call it his crime crushing bonus when he got overtime.
It's Tyler Russey, Russey.
All right, I'll wait for that, sign it.
All right, thank you, Your Honor.
All right.
And I will see you at 1 o'clock sharp.
Yes, we'll see what happens with that. We've got the whole afternoon blocked off. If you talk with your client and he has a request for further record or wants to change his mind about a plea, we can certainly.
I will, but I'm not, I mean, I'm gone until the 11th, so
As
today's,
of today,
yeah, I'm out of the office as of today. So if the court wants to commute his bond at some point, or reinstate his bond at some point next week, I would not object.
all right, thanks.
No, I appreciate it. And I share the frustration with these cases too.
Well, we did get rid of,
Mr. Edie, or Mr. Eddie, excuse me. That was.
let me, yeah, Mr. Eddie. Let me stop.
Yes,
this.
you would.